Thank you everyone for joining us today for our webinar on the future of text and telemarketing after the Supreme Court's big decision in Facebook versus Duguid. I'm Dan Dean, commercial litigator here at Nixon Peabody. I head up the class action defense team and also the TCPA team. And I'm joined today by a colleague, Leslie Hartford, who's recently joined our TCPA team. Leslie, why don't you introduce yourself?
Thanks, Dan. I'm Leslie Hartford out of the Boston office, IP litigation associate. And as Dan said, I've recently joined the TCPA team after doing some data privacy work in the past couple of years.
Glad to have you here with us, Leslie. So just one note off the top, if you hear loud booming sounds, that is because there is a thunderstorm that's supposed to be rolling through my town any minute now. So apologies for that. Let's talk about just a quick roadmap of what we're going to discuss today. If you've been to our webinars before, we always go over kind of an overview of what the TCPA is. We're going to assume a lot of familiarity at this point because a lot of folks are repeat customers and you're all probably more aware of the TCPA than you want to be. So we'll just go over very quickly a few things, then get really into the meat and potatoes, which is, of course, the big Supreme Court ruling in Facebook versus Duguid, and where we will explore whether, in fact, the Supreme Court do good or not. Sorry for the pun. We will also talk about the FCC's new regulations under the Traced Act, which actually came out just a few months before this big Supreme Court ruling. So it's been a very eventful few months for TCPA practitioners. And so we'll get into that as well. And then we will, as we always do, talk a little bit about our advice for best practices and tips for compliance. And we will answer some questions in the Q&A at the end of the presentation. So without further ado, we will start out with the spoiler alert. I first want to start by saying this is a huge win for businesses. We don't want to undersell that. I know as lawyers, we always warn about what the risks are and what we're worried about. So there's going to be a lot of worry and risk talking on this presentation. But we should pause for a second and say this was a big win for businesses that want to stay in touch with their customers or their prospects, via telemarketing phone calls or text messaging. Definitely a huge decision. If you'll recall from our prior webinars, it was back in 2015 when the FCC issued its big declaratory order on the TCPA that really expanded a lot of aspects of the statute and the definitions in the statute and really drove a lot of litigation. We saw a little bit of a scaling back after the DC Circuit issued their decision kind of rebuking the FCC in 2018. But this decision from the Supreme Court really is a major hit on the auto dialer aspect of the TCPA. That said, the TCPA is definitely not dead. It's far from dead. The auto dialer provision lives on, although definitely with a more narrow definition attached to it. But there are also many other provisions of the TCPA that are still important, and in fact, maybe more important today than they were previously. And there's other laws as well that we'll talk about. So telemarketing compliance remains extremely important in this environment. So I usually do these slides on a TCPA overview, so I'm happy to have Leslie here today to do a quick run through and tell us, why do we care about this TCPA statute so much?
Sure, thanks, Dean. So the TCPA is a federal statute. It regulates calls and texts to mobile phones and calls to residential phones. It provides civil liability with uncapped statutory damages of $1,500 per call or text that are found to be in violation. This uncapped liability, combined with the fact that it's really easy to assert class-wide liability on these violations, has led to demands seeking tens or hundreds of millions of dollars. making this a cottage industry for plaintiffs, class action lawyers, and professional plaintiffs. The TCPA litigation grew even more after, as Dan mentioned, the FCC's expansive interpretation of the auto dialer in 2015. The TCPA regulates the use of specific technology, including automatic telephone dialing systems known as ATDSs or auto dialers, and this is what Facebook versus Duguid is all about. It also regulates pre-recorded or artificial voice messages. It regulates text messages and faxes, if you can believe businesses are still using faxes as their telemarketing strategy. The statute also includes enforcement of the do not call list at the national level. So even if you're not using any of the above technology, you do need to be careful not to violate the DNC by calling someone who's on the national DNC list. So the big question, of course, is what is an auto dialer? Here's the infamous ATDS definition from the TCPA. An auto dialer is equipment which has the capacity A, to store or produce telephone numbers to be called using a random or sequential number generator, and B, to dial such numbers.
So I'll just pause here because obviously this is the important part of the Supreme Court's decision is determining this definition. You've seen this if you've been on our prior webinars. We always talk about this definition. It's kind of a mouthful. What does it mean? So the litigation has really focused on three parts of it. One is, what does this word capacity mean? The second is, what does it mean to store or produce phone numbers using a random or sequential number generator? And the third is, what role, if anything, does human intervention play? So for capacity, the question is, does the equipment does it have the capacity to act as an auto dialer? And we've seen varying views as to what capacity means. The Supreme Court kind of skips that and really focuses instead on the second part of the definition, which is really what we call the functionality. What is the functionality of an auto dialer? And the last part on human intervention, you don't see human intervention in this definition anywhere. There's no human intervention to highlight on here, but it's really taken from the first word of the word that's being defined, automated. What makes it automated? The more human intervention is generally seen as taking something out of being automated. So Leslie, can you kind of walk us through Noah Duguid's case against Facebook?
Absolutely. So this case arose from some text alerts that Noah Duguid received about potentially suspicious logins to his Facebook account. As some of you might know, Facebook uses an automated system that sends text to its members upon certain events occurring, one of which is a potentially suspicious login. Facebook uses a stored database of members' numbers in order to send these texts. The problem was Duguid wasn't a Facebook member, so he argued that he had not consented to this messaging. He brought a class action against Facebook for using an auto dialer to call or text cell phones without prior consent. Duguid brought this case in federal court in California, and that federal court dismissed his complaint, finding that Facebook did not use an auto dialer in this situation. On appeal, the Ninth Circuit reversed, holding that an auto dialer only needed to be capable of storing numbers to be dialed automatically later. After the DC Circuit struck down the FCC interpretation of auto dialer a few years ago, a split developed in the US Courts of Appeal. The 3rd, 7th, and 11th Circuits adopted a narrow definition of auto dialer, requiring a random or sequential number generator as a necessary element. Those words are obviously taken right from the statute definition. The 9th and 2nd Circuit adopted a broader definition that would include systems that merely store numbers to be automatically dialed. Supreme Court granted cert to resolve this issue. So what did the Supreme Court say? They sided with Facebook and the arguments that TCPA defendants have been raising for years and adopted a very narrow reading. Their decision focused on the functionality of the equipment or the device used. To be an auto dialer, the court said, the equipment must use or be capable of using a random or sequential number generator, whether storing or producing numbers.
That's right. And so you could actually rewrite the definition another way to make it clearer what the Supreme Court is saying here. And that is, to rewrite is essentially to say an auto dialer is equipment that has the capacity, again, there's that word capacity, to store phone. So, well, actually, why don't I say to A, store phone numbers using a random or sequential number generator, or B, to produce numbers to be called using a random or sequential number generator and to dial such numbers. The important thing is that random sequential number generator is modifying both store and produce. So it's a, the outcome is a very narrow reading on what is an auto dialer. It has to have that random or sequential number generator capability in order to be considered an auto dialer. And the Supreme Court is very clear about that. That's what it says. But what doesn't the opinion say? And that's pretty important too, because there's a lot that's not said. As I alluded to previously, the Supreme Court completely avoids the issue of what does capacity mean. I started to go into this a little bit. Other courts have previously said, under the most, in my opinion, reasonable interpretation of the plain language, capacity means the present capacity. So at the moment you press send to send the text message or to initiate a bunch of calls, does that system that you're using, that equipment, that software, does it have the capacity to sequentially or randomly generate phone numbers? The FCC, however, had previously, back in that 2015 order, taken a very expansive reading of what capacity meant to include anything that could potentially in the future have that capacity. So for instance, if you had a system that wasn't at all operating like an auto dialer, but you could at least theoretically download an app to the system that would allow it to generate random and sequential numbers, well, now we're going to consider it an auto dialer for TCPA purposes. That's what the FCC said. The DC Circuit criticized that. The Supreme Court could have come in here in this opinion and completely slammed it down and closed the door, but it didn't. It stopped short. It just didn't address the issue. So guess what? Plaintiffs' lawyers still have some sliver of hope to make arguments in auto dialer cases. They're obviously going to argue that capacity is the broad definition. So even things that aren't presently acting like auto dialers, if there's, theoretically they could be changed to become an auto dialer, they should be considered an auto dialer. Also, the Supreme Court didn't help things by having some inconsistency in their opinion. At one point, they defined the auto dialer as equipment that must use a random or sequential number generator, just completely omitted the word capacity. Later on, they more properly said the necessary feature of an ATS is the capacity to use a random or sequential number generator. So that is actually the proper definition. The first one is great. We'd rather it be the case that you have to actually use the auto dialer capability in order for it to be considered an auto dialer, but that's not how the statute's written. So long story short, the waters are still a little muddy on what capacity means, and we expect to see further litigation on that. The other thing, the Supreme Court, well, it's not that the Supreme Court didn't say it, but it kind of took out a line of defense. In footnote 6 of the opinion, the Supreme Court seemingly put an end to the human intervention line of defense that I alluded to before. The courts, again, have applied varying tests on what it means to be automated and looking at various levels of human intervention. So, manually entering phone numbers into a headset or into a computer, manually drafting a message, manually determining when a group of messages will be sent, all these different times when a human being is required to do things take a system out of being considered automated. But the Supreme Court said it's just too subjective. When is that line crossed? We don't think that Congress intended that kind of line drawing. So the Supreme Court just tossed that whole line of defense about human intervention. It just doesn't seem to be relevant after the Supreme Court ruling. The other thing Facebook does not talk about, because it wasn't an issue, is what about the other TCPA prohibitions? So there's prohibitions against using pre-recorded and artificial voice messages and sending those calls. And also, as Leslie mentioned, the do not call rules, completely untouched by the Facebook ruling. So those are still there. And we'll talk more about those in a minute. So I know what you're all thinking. Is my system, the system that my company is using, is it an auto dialer? And I can't give you a simple answer in this webinar, other than to say, it's going to be a case-by-case analysis to determine whether your system has the capability of using a random or sequential number generator. And that might mean looking at the source code, see how it's programmed. But I can say, most modern systems that are designed for modern marketing strategies are probably going to fall outside the definition that the Supreme Court has set forth. And that's because, when the TCPA was enacted, marketing was much different. Telemarketing, it was, carpet bombing, plugging a phone book into an auto dialer and just hitting, a whole area code with the same message, whether these people wanted this call or not. And, many of them were pre-recorded calls, just, the same message to everybody. Today's businesses are much more targeted. They're seeking to interact with their customers or with prospects or other people who have shown an interest in what they're offering. They have targeted, customer lists and databases, and that's who they're seeking to interact with. The vendors that are helping these businesses that are supplying systems have therefore changed their systems to be more targeted that way. And there's generally no reason to have random or sequential number generators that are just coming up with random numbers and dialing. Most businesses don't need that today or don't want it. And this definition, although the Supreme Court only just issued this ruling, the first of this month, this definition has been on the books since 1991. So, vendors that were looking to avoid TCPA, have been designing systems to do that for some time now. So, long story short, if you're using a modern system, there's a good chance you fall on the right side of the line. But you should assume nothing. You should talk to your vendors, talk to your lawyer. Of course, feel free to give us a call. We're happy to help you walk through it. Talk to your vendor, talk to your IT person, and figure out whether there's a risk that your system could be considered an auto dialer. But we'll say with text messaging, seems like this is a really good ruling for businesses that like to send texts. I mean, I won't go so far as to say go ahead and send text without consent, but the system that was at play in Facebook was an automated text alert system. Facebook was sending text messages to its members, about login notifications. So one would expect that type of system is going to be fine under the Supreme Court's definition. Where you might run into trouble is there are more, so-called blast text systems that are hitting a broader audience, rather than the more, individual one-on-one texting programs. So that might be more problematic, and you want to take a close look at it. The other thing too is, and as we're going to emphasize in coming slides, don't toss away your compliance regime. It's good. Get consent when you can. Take it slow for now. Why don't we see how these cases develop? I expect over the next year, we're going to see a fair amount of litigation regarding, what is and what isn't an auto dialer under the Facebook analysis. and we'll get a lot more certainty on where to draw the line. Okay, so as the Supreme Court loves to do whenever it strikes down a statute or construes a statute very narrowly, it tells the the party that lost and the advocates for the other side, if you're unhappy with it, go to Congress. We didn't write this law; they wrote it. We just interpreted the plain language, and this is what it says. So, of course, already Senator Ed Markey, he's one of the original drafters of the TCPA. He came out with a statement right after the Facebook decision, panning the decision, saying it's bad for consumers, and vowing that there'll be new legislation to address it. I would expect to see bills circulating in the Senate Committee on Commerce, Science, and Transportation, which generally has jurisdiction over the TCPA, and that's a committee that Ed Markey's on. And certainly possible that we'll see Democrats introducing legislation for, something like a superpowered TCPA 2.0. Could be more expansive and more protective than even what we had, 5 years ago. But the question remains: will they get bipartisan support? Will they get Republicans on board? There is bipartisan support to fight robocalls for sure, and we've seen that, and we're going to talk about the Trace Act. So Republicans don't necessarily hate the idea of legislating against robocalls. However, they also hate class action lawyers. You see the acronym here. The TCPA has commonly been called the Total Cash for Plaintiffs' Attorneys Act. And that, not unfairly. It's, as Leslie mentioned, it's been a cottage industry for plaintiffs and for folks who have made themselves professional TCPA plaintiffs, just making a living out of filing these complaints. And, often against legitimate businesses who are doing the best they can to comply with this very complex statutory and regulatory regime that's been dynamic. The rules have been changing, and when you're sending thousands, tens of thousands of calls and texts, it's hard to be perfect in compliance. So, the class action lawyers have preyed on the legitimate businesses who aren't really the bad actors. So, remains to be seen whether we'll actually see a real push to enact a stronger TCPA, but it's certainly a possibility, especially, if the plaintiffs are correct that this decision unleashes a torrent of robocalls. And we're just gonna have to wait and see if that's the case over the next year or so. In the meantime, you have the FCC also. They could weigh in on what is capacity, since the Supreme Court left that to the side. But right now, the FCC only has 4 commissioners. They need 5, so we'll have to see a commissioner appointed and confirmed. So stay tuned on that. So I'll pass it back to Leslie to summarize.
Yeah, so what happens now? To put it bluntly, the TCPA is down, but not out. First, we expect plaintiffs' lawyers to fight to save their auto dialer strategy by arguing for an expansive interpretation of capacity. As Dan mentioned, the Supreme Court didn't touch capacity, and that is sort of the next open question. Remember, too, that the other provisions in the TCPA regarding pre-recorded and artificial voice messages and the do not call regulations remain fully intact. They're not at all affected by this decision. In fact, under the FCC's new report and order that came out under the Trace Act at the end of last year, these provisions have actually gained strength while the auto dialer provision has been weakened.
So Leslie mentioned the Trace Act. I think I might have too. So what is the Trace Act, Leslie?
So the Trace Act is an excellent example of why we use acronyms for legislation. The Trace Act is an acronym for the Telephone Robocall Abuse Criminal Enforcement and Deterrent Act. It was passed in early 2020, and it was designed to recognize the fact that the TCPA wasn't working to stop robocalls. It was really just making money for class action lawyers. It was driving up compliance costs for legitimate businesses. But really, the TCPA was not stopping the truly abusive, fraudulent robocalls that we all receive. The problem, of course, is that TCPA lawyers don't sue these spammers and the fraudsters because they can't collect from them. Instead, they end up suing legitimate businesses who sometimes make good faith compliance mistakes, but have the money to pay a judgment. Therefore, the Trace Act came out to go after the real bad guys. It strengthens FCC enforcement and it puts notable obligations on carriers. The carriers are now obligated to provide call authentication services and to provide call blocking services free of charge. But the Trace Act also instructed the FCC to revisit some of its exemptions to the TCPA private action provision. The FCC had 1 year to issue a new rule on these. There were 2 important exemptions that were under consideration. The first set of exemptions were for calls made to cell phones. Those created exemptions for package delivery companies, inmate phone services, certain financial institutions, and certain healthcare calls. Those healthcare calls were regulated under a different set of HIPAA considerations. The second exemption was for residential lines, and these exemptions included emergency purposes, non-commercial purposes, commercial purposes that are not advertising or telemarketing, calls made by nonprofits, and those, again, delivering healthcare messages. So Dan, do you want to tell us what the FCC did about these exemptions?
Sure thing. Yeah, so the FCC did issue a report and order. It came out on December 30th, 2020. So just, I think, right on the last day that they had to do it, waiting for the last minute. They really didn't change the exemptions much for calls to cell phones. These exemptions already had detailed caveats and limitations within them. If you actually have bothered to look at the rules themselves, they went on for a couple of pages. So you'd have this list of exemptions, but then all these different limitations and caveats, which would negate the exemptions. For artificial and pre-recorded calls to residential telephone lines, when you look at those exemptions, much shorter paragraph about those exemptions. So the FCC went back to work on those. And one thing that they did was they added frequency limitations to those type of calls. Those frequency limitations already existed for the cell phone calls, but not for the artificial and pre-recorded voice calls to residential lines. So now, under this new rule, any non-commercial or commercial calls that are not telemarketing, so informational calls to your customers about with account information, and nonprofit calls are all limited to 3 calls within any 30-day period. Also, the healthcare messages, which are regulated under HIPAA, are limited to 1 call per day or up to 3 per week. Now, that doesn't mean you can't make more than that amount of calls. That's just if you want to fall under the exemption. If you don't want to fall under the exemption, that means you're going to get prior express consent. If you get prior express consent, you can make as many calls as you want, or as many calls as the person consents to receiving. Now, there's one ring, and well, I will also say prior express consent to kind of review, because we haven't gone over that in this presentation today. That's the easier form of consent under the TCPA. That's it can be verbal, although we always recommend you get it in writing. But basically, it's the voluntary provision of a phone number to the company, the business, whoever's going to be calling, by the consumer. So they fill out an application or they fill out a form and they voluntarily put their mobile number in it. They are consenting to receive messages from you, at least with respect to whatever the relationship is that you're entering into. I mean, you couldn't text them or call them about something that's completely unrelated, but you'd have permission to call them about the relationship you're entering into. The problem with the FCC's new rule is that with the order that they issued on December 30th, they issued a proposed new rule, and in it they, I think by mistake, cross-referenced to some old language in the rules about prior express written consent. So it appears in the proposed rule that you actually need prior express written consent, which is the high form of consent that you need under the TCPA. It's always been only reserved for telemarketing calls. So when you want to send telemarketing calls to people, you need to get prior express written consent, and that consent means you need a signed writing saying specifically, I consent to, I want to receive calls sent using an auto dialer or an artificial or pre-recorded voice onto my mobile number with a telemarketing message. Within the definition itself, though, it's saying these are telemarketing calls. So it's pretty clear to me that the FCC did not intend to require this prior express written consent standard to apply to non-telemarketing calls. It's in the definition that these are for telemarketing calls. So I think this is just a scrivener's error, a mistake, and the FCC will probably fix it within the coming months. I think they've already received comments about it. Okay. So some other things that the Trace Act regulations do. They've added opt-out requirements for non-telemarketing calls. So again, they're putting more regulations around telemarketing calls and also more regulations around residential lines. The rules that we've talked about in the past really focused on cell phones and telemarketing. That's where things were the most stringent. Now we're seeing, and maybe this is in part to do with the fact that there's the pandemic and people are at home. Some people still have residential phone lines and they don't like being hassled at home. So we're seeing more focus on the residential phone calls, and we're also seeing focus on non-telemarketing calls. So now you have to include in your pre-recorded or artificial voice phone message calls to residential lines when you're making these calls without consent. You have to include a prompt at the beginning of the message that gives them a chance to opt out. So, something like, press *9 to stop receiving these calls. And then if you get that message back, you have to stop the call immediately and put that person on your internal do not call list. You have to stop calling them. That's, again, a new requirement for non-telemarketing calls. They used to exist for telemarketing, but now it also exists for non-telemarketing calls. Same thing with text messages. We, in prior webinars, we've always given you the best practice advice with all text message campaigns to include an easy opt-out, easy opt-out instructions, which for text is usually reply stop to cancel. That's pretty ubiquitous. That's what you'll see when you get text messages. That is now basically the rule for both marketing and non-telemarketing. You send the text, give them the easy opt-out. And another best practice that has been codified by the new rules is keeping the internal do not call list for your customers, again, regardless of whether it's a telemarketing call or a non-telemarketing call. Again, it used to be just telemarketing calls. You had to keep an internal do not call list. Now you should do it for both purposes, even for non-telemarketing calls. If you call someone that is on your internal do not call list, even for just a non-telemarketing call, you could find yourself with a TCPA complaint. So another area, of continuing concern is, of course, state laws. So I'll turn it back to Leslie to talk about that.
Sure. So in addition to the federal TCPA and the Trace Act, there are also state statutes that regulate automated calls and auto dialers in many ways. In fact, almost every state has some statute addressing these issues. The only states without them today are Delaware, Hawaii, Idaho, Ohio, Vermont, and West Virginia. Much like the TCPA, many of the state statutes do have exemptions for information-based calls, particularly those related to health and safety, and calls to customers with pre-established business relationships with the caller. So again, the exemptions are similar to the TCPA and allow callers to sort of opt in and allow businesses to interact with callers with whom they already have relationships. In addition, some states, including Tennessee, Michigan, and Wisconsin, also maintain their own state-specific do not call registry and enforce violations of that list at a state level. So it's important to know if you're calling into a state with a DNC list. Not only do many states have TCPA-like statutes, some of these statutes are even more restrictive than the TCPA itself. For example, California's auto dialer definition includes equipment that stores phone numbers and has the capacity to send a pre-recorded message to those numbers. Illinois has a similar statute and a broad definition that encompasses devices programmed to access stored numbers to send pre-recorded messages. So unlike the TCPA, these statutes do not require that the storage function be accomplished using a random or sequential number generator, which you'll all recall is the phrase that was just litigated in Duguid. So the bottom line here is, even if you are safe using an auto dialer without consent under the TCPA, if you call into one of these states, you could find yourself with a lawsuit under a state telemarketing statute.
Okay, thanks, Leslie. So we're now on to the portion where we talk about TCPA best practices. And as I've urged earlier in the presentation, please do not ditch your best practices because of Facebook. Facebook only deals with the auto dialer portion of the statute, and even as to that provision, we still have some litigation. We still have some ambiguity in what the Supreme Court meant, capacity and the like. So, continue to maintain these best practices to minimize any potential liability. In fact, I'll note, I just saw today already some statistics since Facebook was decided. There's already been an uptick in do not call lawsuits filed this month. So the plaintiffs' lawyers are not going to just give up on the TCPA and pack up and go home, stop filing lawsuits. They're still going to try to drum up business, and they know the TCPA, so they're going to keep trying to figure a way to bring TCPA lawsuits and recruit plaintiffs to bring those suits. So it's not going away. If you've been on our webinar in past years, you've seen these slides before. Although the law has shifted on some of these things, the best practices have largely stayed the same. If you follow best practices, I won't say guarantee that you'll stay out of trouble, but it certainly minimizes risk. Consent, as it says in the slide, consent remains king. It's your first line of defense, and it's your best line of defense. It will prevent lawsuits. It will prevent class actions. When the lawyer calls you, when I get in touch with the plaintiff's lawyer and I let them know I have records demonstrating that we have the consent of your plaintiff, that pretty much ends the discussion. So get clear consent in your customer agreements if you're going to call customers. And we also urge that you get the highest level of consent. So again, the prior express written consent, even if you're not initially intending to be sending telemarketing messages to your customers, for instance, if you think down the road, you might want to send them, some promotions, or you want to cross-sell, another line of business. It's best to get it bottled up, get the prior express written consent right off the bat at the start of the customer relationship, and then all your bases are covered. Make consent to calls to cell phones and texts explicit in your agreements. You also want to prevent wrong numbers by requiring that folks, when they give you their consent, they agree, they confirm that this is my phone number. I'm the subscriber to this phone number, and additionally, if I change my number, if I drop my number, I'll let you know, or I'll opt out of receiving your calls or your text messages. Make them promise to do that. They might not do it, but it'll be a line of defense for you if there is subsequent litigation because the phone number gets reassigned to somebody else, and then you mistakenly call that person. Mandate methods to revoke consent in a bilateral contract. This is another topic we've talked about in prior webinars. In a bilateral contract, you can enforce those types of terms. Like, you may only revoke your consent by emailing us at this address, or by texting stop, that kind of thing. And the best insurance policy for class actions, aside from insurance policies, is an arbitration clause with a class action waiver. They've been upheld repeatedly in litigation. It compels the plaintiff to proceed against you in an arbitration proceeding without a class, which means the class action lawyers are not interested in bringing those. They don't want to go to arbitration, single plaintiff arbitration. So in my experience, when I've had these, we've enforced arbitration clauses. We've almost always been successful in enforcing the arbitration, and I can't think of a case where the plaintiff subsequently filed their actual arbitration. Once the class action was defeated, that was the end of the case. Again, these best practices should be familiar. If anything, they're more important now than ever after the Trace Act. You want to make sure you comply with all the opt-out rules, including these new rules that we just talked about under the Trace Act, which extends them now to non-telemarketing calls. Again, with the caveat that if you get the consent ahead of time, then you're not making those calls under an exemption. You're making them based on the consent you received. So then you wouldn't need the opt-out necessarily in the pre-recorded call. Although still, it's still, not a bad practice. Maintain good records. If you get consent, that's great, but it's not going to do you any good if you don't have the records to prove it. The statute of limitations on TCPA is 4 years. You'll notice with customer relationships, we recommend that you keep your consent records for 4 years after the relationship ends with a customer. And that's because, if you think about it, if you have a customer for 4 years, and then, that relationship ends, and then 4 years later they sue you, but you've only kept your records for 4 years. When you go back to look for the record of the consent you got 8 years ago, it's going to be gone. So you can't just go by the statute of limitations. You want to go by the customer relationship. Keep those consent records so you can prove, if you have litigation, that they consented to your calls. And then, there's various databases you want to scrub against to make sure you don't get into trouble. And there's plenty of vendors out there that do this for businesses. They'll scrub and make sure that you're not calling any numbers on the national do not call list, or any of the the state do not call list that Leslie mentioned is relevant. They can also scrub against numbers that have recently been reassigned. So again, worrying about wrong numbers. Somebody's number has changed hands, and you think you're calling Bob, but you're actually calling Mary. So go have your vendor scrub for that. The FCC is supposed to become operational with a reassigned number database, which will provide a safe harbor if you scrub your call list against that database. That's not operational yet, but the last I heard, they had contracted with a third party to develop the database and make it operational, and it could be as soon as this summer. So stay tuned on that. And there's also vendors that have the option of scrubbing for commonly known TCPA plaintiffs and the professional plaintiffs I mentioned before. So bad actors that are out there just baiting, just looking for the next TCPA complaint. There's their numbers have been identified, at least some of them, so you can scrub and make sure you're not calling any of those folks. And then the other thing that we always talk about is vicarious liability. You don't want to get sued for somebody else's mistake, somebody else's non-compliance. You'll probably be working with telemarketing vendors, or be buying leads from lead generators, or have other contractors or affiliates who may get in trouble in your name. As we've discussed in prior webinars, courts have generally applied a common law of agency analysis to determine whether you imparted either actual or implied authority to these third parties, or you ratified their actions. You knew what they were doing in your name, and you okayed it. So you can do everything right here, but you have to remember that vicarious liability is a very fact-intensive inquiry. So if you get sued under a theory of vicarious liability, and that's your defense, you want to get out because you say they're not an agent of yours. You just have to be aware that you're probably not going to get out on a motion to dismiss. It's probably going to go at least to summary judgment. You're going to have to put facts in front of the court to establish that there is no agency relationship. So the best practice is, of course, to avoid any lawsuit in the first place, or avoid any argument of vicarious liability in the first place. We, of course, recommend that you work with good, reputable vendors, work with good lead generators that have a good reputation. I've come to know from some of the cases I've defended that the old adage, you get what you pay for, is true. You're buying cheap leads, it's probably because they're rotten. So just keep that in mind. Excuse me. You want to make sure too that your vendor knows about the TCPA. I know that sounds basic, and they take compliance seriously. We heard about a case just in the past year of a vendor that was providing telemarketing services to one of our clients, and lawsuit came across their desk, and they called up our client and said, so what do you guys do about TCPA compliance? And the client said, well, that was you. I thought we were relying on you for that. And they seem to have no idea. So, take it seriously, ask some questions. Again, get your lawyers involved in talking to vendors, and feel free to give us a call. We can help you with that. If you have the negotiating leverage, certainly try to get language in your vendor contracts that warrants that they are going to comply with all laws, including the TCPA, and giving you indemnification, if they don't comply. So we've made it all the way to Q&A.
We did. We actually got some questions in advance. So let's start with those. First one, is Facebook retroactive or only prospective? What does it mean for pending cases?
So the short answer is yes, it's retroactive. Really what you want to think of, conceptually how to think about it is this statute has been on the books since 1991. The language has been the same all this time. The Supreme Court just finally got around to saying, all right, we're going to read it and decide what it says, because the FCC has tried and failed, and the courts all disagree with each other. So yes, it's been a roller coaster ride trying to figure out what an auto dialer is for all these years, but really the law has always been the law, and the Supreme Court now says what it always has been. So what does that mean? I think that means that for pending cases, TCPA cases that have a claim that a defendant violated the auto dialer provision of the TCPA, we'll see motions to dismiss based on the Facebook ruling. For closed cases, obviously, if you've settled in the past or you've got a final judgment, there's probably not much you can do to reopen that. But for any pending cases now, I think you'll see motions to dismiss.
Thanks. That feeds right into our next question, which is my communications platform an auto dialer?
Yeah, I talked a little bit about this before. Obviously can't say on a webinar, whether your particular system is an auto dialer or not, and I'm not even comfortable necessarily drawing bright lines. I did say, that whatever the text notification system that Facebook was using, clearly that was blessed by the Supreme Court. I do think, that the Facebook decision opens up a lot of more possibilities for texting without consent. Although again, I'd still caution you to getting consent is still the best practice. And there is going to be litigation around, okay, let's apply Facebook now going forward. And so, over the next year or two, we're going to see, exactly what systems seem to be well covered by the Supreme Court's ruling, and what systems might still be using kind of outmoded or, technology, or, for whatever other reason, are still seeking to send out blast messages to wide audiences.
So you jumped ahead and you answered our third question too, which is,
yeah.
can we send texts and can we call now without getting consent?
Yeah. So yeah, to kind of harken back to that. Yeah, I would advise, consent is king. Continue to get consent. It's not only good for the TCPA, it's probably also good consumer relations, customer relations. People tend to be more receptive if they've given you permission to call them at home or on their cell phone. And it's best practice still, I would say, for the TCPA, and certainly, if you're in any of those states with their own auto dialer laws that Facebook might not be addressing. So yeah, I would still recommend that you get consent.
And that sounds like it also is part of the answer for our last question, which is, what about contacting employees? How is that different or the same?
Yeah, so I did see that question and wanted to address it, just to point out that it's not really different. Although we generally tend to talk about consumers in this presentation, employees are people too, and it's basically the same rule. A lot of employers will harvest contact information for their employees when they hire them, or during the course of the relationship. And if you get their phone number, they voluntarily provide it to you on a form or whatever. They're saying you can give me calls or send me text alerts that are relevant to my employment with you. So you are getting that level of prior express consent. For telemarketing, though, we advise you get that. If you want to market to your own employees, that you get that higher level of consent, and that will require written disclosures and assigned writing back from your employee. So I think that I'm looking, I do have one question here. If we do not use an auto dialer, does that mean we do not need consent to send a text message, regardless of whether marketing or non-marketing? Yes, if you're confident that it's not an auto dialer, and that's just a question of determining what the system that you are using is that does that comply with the Supreme Court's new ruling. That is, does it have the capability of randomly or sequentially generating numbers? And again, that might mean diving into source code to determine that, or talking to the vendor who operates the system that you have. So I also just received a reminder that we do have a CLE code. So let me jump ahead to that. So the attendance verification code for this webinar is NPCLE 42121. Again, the verification code for CLE credit, NPCLE 42121. If you are seeking CLE credits, you need to complete and return your certificate of attendance and send the form to Vanessa York at the email address or the fax number that's indicated here. So again, NPCLE 42121. So we're going to send a a thank you email around, and if there's any other questions we didn't address, we'll answer them in our key takeaways. And of course, you can always reach out to me or Leslie with any other questions you have anytime. So I just want to thank everyone for joining us today.
Thanks all.
Thank you.